Welcome to Cyber Focus from the McCrary Institute, where we explore the people and ideas shaping and defending our digital world. I'm your host, Frank Cilluffo, and have the privilege today to sit down with two experts on a topic that I think is front of everyone's mind when it comes to cybersecurity. The recent Supreme Court overturned Chevron deference, and it has implications that are broad in a whole bunch of policy areas, but also have a number of specific cyber flavors. Here to shed light on this topic, we have Ari Schwartz. Ari is Managing Director of Cyber Services at Venable, and Harley Geiger is Counsel on cyber issues at Venable as well. Both come at this issue with a lot of expertise. Ari was a Special Assistant to the President, has Executive Branch expertise on cyber-related issues, did stints at Department of Commerce, and Harley comes at it from a legislative perspective, having actually drafted legislation on Capitol Hill in the past. Gentlemen, thank you for joining us today. I thought we'd start with sort of stepping back and actually trying to make sense of what the ruling itself means and Chevron deference, just generally speaking. Harley, you maybe want to take a first crack at that?
Sure. So in talking about Chevron deference, I think we're going to take a big step back and go to something, start real basic. So we have in this country three branches of government, right? We have the Congress, the legislative branch, which will make the laws. We have an executive branch that enforces those laws. And we have a judiciary, which decides questions about those laws. So Congress makes a law, it's ambiguous, or there's a lot of vagueness in the law. This happens all the time. And an agency is tasked with actually enforcing that law. And to do that, they have to interpret what Congress said. They have to make interpretations about those vague terms, those ambiguities. So they do. They have a rulemaking, and they will require companies to do things or require individuals to do things. When individuals or companies don't, according to the agency, they can bring an enforcement action. Now, when that happens, it can get challenged. So an individual or a company or another government agency even can challenge that regulation. And they might say in those court cases, we don't think that this regulation is what Congress intended. The agency is supposed to carry out Congress's intent when they're making a regulation or enforcing it. And we think this went beyond what Congress intended. Now, Chevron comes from a court case in 1984. This is Chevron versus the Natural Resources Defense Council. And what that said was that at this point where a court is hearing a challenge to regulation or an enforcement action, and somebody is saying, we don't think that this is what Congress intended. At that point, under the Chevron doctrine or Chevron deference, courts were supposed to defer to the agency. They were supposed to say, well, look, we're going to give a lot of weight to the agency's interpretation of Congress's intent. That was in place for some 40 years. And we had gotten into a rhythm in regulation in this country where Congress was able to pass sort of open-ended, ambiguous laws and then leave it to agencies to sort of fill in the gaps. And it was harder back then to bring up a challenge against regulations saying that the agency had overstepped their bounds. Now, fast forward to just a few weeks ago, the Supreme Court took that doctrine and tossed it out. It had been in place for 40 years, it's no longer in place. And what it means is when there is a question before the court about whether an agency regulation or an enforcement action is what Congress intended, whether it's valid authority, the court no longer has to make that deference, no longer has to defer to the agency. The courts will decide for themselves. And there will still be some deference. They'll still take into account what the agency thinks is Congress's intent, but it does not take nearly as much weight as it did previously. As a result, regulations are more vulnerable to court challenge. And now judges have greater power to reverse or modify regulations or enforcement actions because they can act independently without having to defer to those agencies. And this has far-reaching implications for cybersecurity policy, but also virtually every other regulation in this country.
Harley, thank you. And I'm definitely going to want to pull on the thread on whether or not we think the Judicial Branch is equipped and has the wherewithal to really weigh into this. But before we jump into that, I want to sort of get, Ari, some of your thoughts. So what impact, and I know it's early days and precedents are actually being set potentially, and I'd love to pull that thread in a little bit, but what do you think this means for cybersecurity policy? What's the executive branch doing right now?
It could have a major impact and likely will have a major impact on cybersecurity because most tech policy is written with that open-ended piece to it. They don't want to, Congress doesn't want to fight over technical pieces of technology. So either the technical side of the standards, or what type of technology they're going to use, or what how to go about making certain kinds of decisions, or the kind of weeds of what's the best solution for a technology in the space that might change in the next 10 years or 12 years. So they leave a lot to the agencies historically for technology policy, and cybersecurity is no different from that. So we see a lot of openness.
And this administration probably even more so than most, correct?
Correct. I think, this Congress and this administration, right? You have the Congress that's leaving things more wide open, and a administration that's more apt to be interpretive of the open space there.
So what do you think there, and this is for both of you, what do you think agencies are doing right now? So if you're at CISA or at DOD or at DOE or at the NSC, as some of us have lived in the past, what do you think's going on right now?
I think, from the career side, there's really not much difference, right? Especially over the last 10 to 12 years, you've had different folks come in, and their view is always, our job is to interpret the law that Congress gave us and to implement it the best we can. And we know if they gave us a lot of latitude, we better be able to prove that we're doing this in line with what Congress said. That said, sometimes the political will push things in a certain direction, and now they have to be more circumspect about that. I don't think there hasn't been a new set of rulemaking where we've seen that in place just yet. But when you talk to the career folks about it, they say it doesn't have an impact on us direct. They don't love the idea of having worked on a rule for 4 years and having it get thrown out. But they also but that was the case before too. So
Harley, I see you want to jump in on that.
So I'll just say that for cybersecurity and a lot of other areas of technology law, Congress has not really kept pace with where business practices are, where cybersecurity threats are, and has legislated relatively little in this area. And as a result of that, many agencies have revisited older statutes that had passed in earlier eras, often about protecting consumer information or protecting consumer safety, and adapting that to modern threats. And that is where some of our cybersecurity rules have come from. And agents...
And I would argue, just generally speaking, technology advances so quickly that we're always going to be laggard a little bit, right? Whatever law we put in place might be overtaken by events to an extent, principles aside.
To an extent. I think we should revisit that perhaps. Privacy and cybersecurity, I think, have long been around to the point that we probably could be further ahead than we are in terms of legislating on it. And but within agencies right now, we know that agencies that have proposed rules are looking at those rules, and in light of this new legal landscape, post-Chevron deference. I saw a story just this morning that the NSC is looking at proposed rules on hospitals for whether or not they will survive or be modified post-Chevron.
Are there any precedents set thus far already that you're seeing?
So,
I mean, this is days old. It's not years old, but...
So great question. And the answer, I think, is yes. There is a precedent in a recent case that just came out. This is the SolarWinds case. The district court made a ruling on that, and one of the things that was at issue in that court case was the SEC's charges that the company's internal controls for cybersecurity were deficient, and the SEC used an authority that actually, if you look at the statute, says it's internal accounting controls. And but the SEC has for some time been using this authority as a cybersecurity authority and has extracted multi-million-dollar settlements from more than one company when they have had cybersecurity incidents or some sort of alleged failing in their security controls.
So I understand this. It's not only looking forward, but it also has the potential to look through rear view mirrors and roll back, repeal.
Absolutely. And just to finish the thought, in this case, the court ruled, and this was just last week, the court ruled that the SEC did not, in fact, have this authority. So this is the first time that this was brought before a court, and the court said, looking at the statute, it says internal accounting controls, not cybersecurity controls. This is clearly intended to be a financial control. And so this is something that if it were challenged again by the agency and reviewing whether or not they have the authority, this is a post-Chevron question. Right? We look at the statute. What did Congress intend? How is the agency actually carrying this out? And before this decision, which is, by the way, the Looper-Bright decision, before that decision overturning Chevron deference, the court would have to defer to the SEC. That is no longer the case. So it's actually a seismic effect on regulations.
I would say there have been some experts that have looked at the court ruling and said, well, it's not going to have that big of a difference because it's settled law. The court said settled law is settled, and we're not going to go back and change all that. However, in this case, it hadn't been brought before, right? And so, and most of the cybersecurity cases we're going to see haven't been brought. There hasn't been a challenge in the courts before, so it is very impactful in a space like cybersecurity, where the law is newer and there hasn't been, and the regulations are newer, and there hasn't been that many challenges.
And I definitely want to pull the thread on congressional intent and how Congress can better work with executive agencies and obviously judicial. But before I do that, and again, this is early days, we don't know what the full impact would be, but a lot of emphasis to harmonize regulations. What does this mean for harmonization? Does that sort of make this OBE?
I don't know. I think if Congress can get that into the laws, right? And gets to talk about harmonization being a key piece and how we do that, make that work across different sectors, and working internationally, right? That could be a driver to make things make more sense in this space, that they don't have to go through each different piece of this in such great detail if they can agree on okay, this is the type of certification that people have to have or something that people have to understand. If Congress can agree on that, right? So it could be a help, but if they can't get to that point, then it's not going to help.
And the good government person in me hopes that would in fact be the case, that it could actually drive positive change. But Harley, I'd be curious what some of your thoughts are.
So my take is that harmonization is going to be more difficult than it would have been if this Supreme Court decision did not change the legal
patchwork. Is
that is where I see this going. That's right. But for an immediate term, Congress has woken up to the problem of inconsistent regulations across sectors. There's more than one hearing on this. There's more than one bill now that is looking into this. But none of these actions by Congress actually give agencies authority to get rid of their existing regulatory structure to go to a harmonized regulatory structure. And until they have that ability, then anything that the agencies do to change their regulations is now more vulnerable to legal challenge. So I think to Ari's point, part of the key here is going to be whether Congress can get its act together and legislate on a harmonized cybersecurity regulatory framework. And frankly, I don't see that being imminent.
And I would also add whether or not they have the expertise, because most laws are, you can, I don't want to say drive a truck through, but they're pretty subject to interpretation. Now I think you are going to have to be a little more, or a lot more prescriptive. And what do you think that means?
Well, I think they can go two ways. So Congress can be prescriptive, or Congress can give a lot of power explicitly to agencies. I think that the problem here is not whether it's possible. I think that the problem is more political. In general, it has been a political politically contentious to give agencies a lot of rulemaking authority. If agencies clearly have rulemaking authority, and if that rulemaking authority is clearly broad, then there's not an issue of congressional intent. But in general, for things like privacy and security, there has been a reluctance for Congress to do that. So the other route, as you suggest, is to be very prescriptive in legislation. That has also been difficult. You enshrine something in legislation, it's very hard to change. And as you noted, technology does change pretty fast.
Especially as it changes quickly. And I would just add that sometimes there is a difference between oversight of security agencies and those that have regulatory authorities. It gets a little complex, but I think that is one of the differentiators from that I think will factor into some of that decision making.
I would say, in this administration, the White House has said, we're going to be creative. They literally have said, we're going to have creative use of regulatory authority as it relates to cybersecurity in order to make sure we're covering sectors where there hasn't been any action. That's gone now.
We've been there before, and those are, to serve the American people at the White House is a privilege of privileges. But what do you think this means now? If you were in your old job, this would demand a wake-up call, no?
Yeah, I think it would. I think it would change the strategy. It would drive you. This administration,
progress. I feel like
has felt like legislation happens too slowly for the cyber threats that we're seeing today, and they purposely aimed at procurement policy, which could still be the case here because this does not cover procurement policy. So they would be, but they want to make sure they're covering stuff in sectors and that aren't necessarily government contractors, right? So they're also are looking at we're looking at regulation. To do regulation now means legislation, right? They cannot no longer say legislation takes too long. They have to engage with Congress in order to get things done.
And Harley, what do we think about the judicial branch in particular? Do they have the staff? Do they have the expertise? Do they have the desire to jump into this in the way they need to? Or it looks like they might.
I think the answer is no, that they don't generally have the staff or the resources, particularly in comparison to agencies when it comes to technology and other non-legal topics. If anybody has worked with congressional offices, you know that they are already on a lean budget. Judicial offices tend to be on a leaner budget still, but they're going to be facing these deeply technical cases in a variety of areas. Again, not just cybersecurity, privacy, technology, the environments. There is now potentially a great wave of litigation that can come as a result of this particular decision. And one of the things that I think is important to notice here too is that our structure, our judicial system, is divided into districts and circuits. And we have a state system, a federal system. These courts can reach differing conclusions, and one circuit does not necessarily have to be bound by the decisions of another circuit, and until it is resolved by the Supreme Court. And so we might see theoretically more circuit splits, which for companies that service an entire nation, that suddenly makes your compliance picture that much more difficult.
Which is already difficult for a number of companies that have to transcend. I do want to get to what the implications are from a private sector and corporate perspective, but sort of before I leave the judicial piece, I go back to some of the counterterrorism when we were getting judges up, bringing them up to speed on TFTP, a number of complex related national security issues. There was a massive education campaign to all of that. Do you see that happening here, or do you think we're going to see individual cases have outsized precedent and impact?
I think it's too early to know on the educational piece. So it took a while, but in my opinion, both Congress and the executive branch agencies have actually done a pretty admirable job of shoring up their technical chops. They have created programs where they can have a tech Congress fellows, where they have detailees, And there's a fair amount of expertise, especially in agencies, but also to some extent in Congress, that was just not there maybe 10 years ago. So they've gotten a lot better on these subjects. I have not seen that same effort yet in the judiciary, but I'll note that it took a while for that to really get going with the administration and with Congress. So it's possible.
Sounds like something Venable might want to zero in on, because I think there is opportunity there too, right?
Cannot confirm
nor deny. No, but to jump to some of the private sector related questions, I mean, and without mentioning who your clients are and the like, what are they asking you right now?
Well, I think there are trade associations that are looking at specific laws and regulations that cover them, and whether those are now open to challenge and maybe they weren't before. I think that's a big area of question right now. There's also the question of just what does this mean? Yeah. Do we have to still continue complying with regulations? How do we go about looking at some of these things? And I think for the most part, it hasn't changed anything in terms of compliance yet, right? And companies have to keep going and doing what they're doing from that point of view. So,
and my gut tells me, and disagree, but the narrative I hear is they like some sense of certainty.
This is less certainty.
This is less certainty.
If you are a company, particularly
a general
counsel at a large company, this is going to make you very uneasy. That there is going to be less certainty for a long time now.
So I think our message right now has been not to make any big changes based on this. That
you mean don't throw out your cybersecurity programs?
That's right. That even like it doesn't invalidate. It doesn't until a court rules otherwise. This doesn't invalidate any regulations.
Absolutely.
What it does is make them more vulnerable to being modified or reversed in court. But that process can take some time. Even the case I mentioned earlier took a while, took a couple of years. And so no big changes, but to be aware of it, to track litigation a little bit more closely, and for public policy teams, sort of adjacent to legal teams, to be aware of this dynamic when you're talking with agencies and with Congress, because the strategy of policymaking and rulemaking now has to change if they want to avoid being modified or overturned in court.
And to lean forward on an issue like this, that's actually very smart, because I think it is very early in terms of full awareness and understanding. But the fact that both of you are sitting down today to be part of that informational, I think is a very strong step forward, because I think we're all trying to figure out exactly what it means. What do you think it means, Ari, from a critical infrastructure perspective in particular? If you're an owner operator of a lifeline sector or systemically important critical infrastructure?
It depends on what sector you're in, really, because some of the agencies have very, very clear authority, even dating back even before 40 years of when the Chevron deference has been in place. So I think that if you're in one of those sectors, I think you know what you need to do, and there's not going to be much challenge. In other sectors where there's not clear authority for security, right, then it's going to be harder to bring those kind of regulatory structure and put it in place. We know the water sector challenged the EPA.
Yeah, that was before
even before this,
ruling,
and they won that it was too broad. So certainly, if the EPA thought that was their best place to bring this, whatever they're going to do now is even less so. So I think there's some sectors where there is less certainty. The thing about cybersecurity is, regulatory liability is only one piece of the liability you have to worry about. So I think you should be very focused on the actual security and less on compliance if you're in one of those sectors.
You and me both, because I do worry. The concern I've historically had with some of the regulatory, it does provide that check the box, and and I'm not suggesting done right it leads to that, but that is sort of at least the race to the bottom on some of it. And
we prefer risk management, authorities and risk management regulations that make it so that you know your own business, you figured out, you should demonstrate that you're doing it risk-based. Those are hard to put together, but in a sector that has nothing, I would certainly go much more risk-based. If you're compliance-oriented, you have a checklist. That's still better than nothing in that sector.
So I would say also that the dynamic is now such that it's going to be broadly deregulatory in the absence of new congressional action, and that it will fall more to individual companies and sectors to manage their cybersecurity risks on a more voluntary basis. And we know that there are many companies that do that and do it very well. But we also know that there are actors that cut corners when it comes to cybersecurity and sort of roll the dice.
It's always too much until the day it's not enough.
Until the day your system is encrypted by a ransomware gang. And I think unfortunately, regulation has in the past provided a means of prodding those types of organizations to take another look at their cybersecurity programs and potentially shore them up. And it's in this environment that becomes a bit more difficult. So the need is still there. The threats are still growing. But it's going to have to be, I think, greater reliance on self-regulation.
And fair to say, and we're not advising legal counsel to anyone here, obviously, but to any company that you're actually advising, whether this changes a whole lot, they still need to have a system, a process, a bunch of steps they've taken to make that case, right? I mean, all things said and done, if they take a risk-based approach, doesn't mean they always have to apply the exact same level of ingredients everyone else's, but they still need to be able to make that case. They need visibility on their systems and need visibility to be able to articulate that they're moving the needle. So I certainly hope no one takes this as a pass on security, but rather maybe a re-examination on what that could look like. Am I fair on that?
Absolutely. And like we said earlier, this does not invalidate any existing regulations. I think what it does is it makes it harder to regulate going forward, for better or for worse. And when it comes to critical infrastructure, as we sort of said at the outset, Congress has not legislated a great deal on critical infrastructure cybersecurity. And so there's been a lot of talk, a lot of voluntary initiatives to create a baseline of cybersecurity practices that can be reused for critical infrastructure. The NIST framework being one, CISA's cross-sector performance goals being another. And it is, I think, very, very helpful that we have that background now. But there also has to be, and I think there is to an extent, industry self-pressure to actually meet them, those best practices and guidelines. And unfortunately, I think that it is less likely that we will see a specific movement to harmonization and cross-sector critical infrastructure cybersecurity.
I want to pull a thread. So what other challenges do you think, and obviously the general uncertainty, but what else do you think we ought to be thinking right now if you were advising some of these entities?
Well, I think as new legislation comes up, there's this question of how much certainty you want in it, right? So do you go with this sense that Harley said, and we give more authority to the agency specifically, the agency can do X, Y, and Z, and it's part of their just general operating authorities, or do we put it into a regulation and have Congress go through all the steps of going about doing it? And I think that those kind of figuring some of those new things out in new law is a
there's a Goldilocks, not too much, not too little, somewhere in between, right? So,
right. If the law's going to happen anyway, you as a company, where does that fit for you? As in a trade association world, is there a way you can do it so that there's more, it's based on existing best practices and things that you've been supportive of from the beginning, right? So, and how do you get that written in there and done in the right way?
So without jumping into all the sort of SEC regulation, but CERCIA, this could have significant implications. Thoughts? Yes, no?
I'm glad you raised that. So CERCIA, this is the Cyber Incident Reporting for Critical Infrastructure Act, and there you do have a statute that Congress passed that did have a fair amount of detail, but ordered CISA to have rulemakings to implement it. And we are in the middle of the proposed rulemaking right now. And so these comments have been submitted. They've now been posted to the website, and CISA is in the process of considering them when Chevron deference evaporated.
Yeah.
And so there were parts of that rule, that proposed rule, that I think struck everybody as being very broad. And that includes the definition of covered entities. So, it's not just applicable to critical infrastructure owners and operators. It's anyone who's an active participant in a critical infrastructure sector. And there's 16 sectors. It comprises a huge swath of the economy. I think a lot of entities did not realize they were going to be swept into this. Another definition, the definition of covered cyber incident that you have to report to. There's not a lot of harmonization, even though the bill that underlies the rule was trying to push towards harmonization. And so it ended up being very broad, very, very detailed in a way that I think caught a lot of folks off guard, including some of the sponsors of the original legislation in Congress.
So from both sides of the aisle.
Yeah.
So Senator Peters, as well as Representative Garbarino, and then separately a group of three, including Representative Green and Swalwell. They all submitted comments saying that CISA had gone beyond their intent. And in some cases, these are the representatives and senators that had sponsored the bill to begin with, and said that in those three areas in particular, covered incident, covered entity, harmonization, that CISA was overstepping congressional intent. That is very powerful ammunition in a court case now that Chevron deference is no longer with us. So if the proposed rule became final in its current form, I think it would be more vulnerable to court challenge. And so CISA, being in an open rulemaking, has to be somewhat tight-lipped about what their internal process looks like. But I am sure that they are looking.
They also got to know they got to be a little responsive. Right. Yeah,
they don't want to see their work in crafting this rule get overturned or modified.
This is actually the first rule that they've ever crafted. Right? This is the first regulation they've ever done, and they've been very, very circumspect about how people can comment and making sure that they're following all the letter of the
and
rules.
This is the bottom of the eighth inning. It wasn't in the beginning of the game. Yeah. So I think that will have implications, right? I mean, we're pretty confident. I'm not a gambler, but I'm pretty confident that will actually have some impact there.
I did not think prior to this developments, the loss of the Chevron deference, that CISA was going to make a lot of changes. I think that the tenor of the rule making was such that I think they wanted to be very broad, and they were going to take ambiguities and turn them into a greater ability on their part to get these incident reports. Now, given both the changed legal landscape and the letters from Congress on what their intent really was, I think that they have to make some changes, or it'll get brought up in court.
I think you're right about that. And you've both spent time in roles at the Center for Democracy and Technology that's looked at. Is there an analogy here with privacy laws?
Oh, you bet. So I think if you look at where privacy is today, Congress waited and waited to actually pass something. It hasn't happened. Industry resisted comprehensive privacy legislation for like a decade, and but then Europe went ahead and moved with GDPR, and states got tired of this, and they also moved ahead. And now we are in a place where we have this tremendous patchwork. Congress is not really able to act because to do so would require coming to consensus on some contentious topics like private right of action and so forth. And it's hard to change where the states already are. They have to think about their constituents back home, and we've been in limbo on this issue in Congress. So we're being led by non-U.S. regulations that apply outside of those countries' borders and the states, and it's a tremendous patchwork. At our law firm, I sit in on meetings with our privacy group, and there is a great deal of discussion always about how to craft privacy policies and internal compliance for different states. Well, we can word our privacy policies to say, if you're a Colorado resident, if you're a Connecticut resident, and it is a very difficult compliance picture. We are headed down that same path in cybersecurity. We talk about cross-sector security regulation, and we are now in a place where Congress is less likely, I think, to move on it. Agencies are less likely to be able to pass a rule that is not going to be open to court challenge. But in the meantime, Europe has already moved ahead. Just like with privacy, they've already moved ahead with security regulations. They've got several, the Cyber Resilience Act being one. And it's a matter of time, just a matter of time before I think states get sick of seeing their hospitals and their own critical infrastructure hit with ransomware, and they start acting as well.
So do you think this will, and Ari, I want to jump, but I just want to pull one more thread on that. Because, I mean, when you look at data breach notification and when you have national perspectives and then every state, I mean, just from a filing perspective, the paperwork is insurmountable, isn't it? I mean, this is a digital problem and a very analog solution.
It's surmountable, but it is a real headache,
of course,
right? But it's a headache, to your point. It's difficult, it's expensive, and it hasn't solved the problem of privacy and data breaches.
And I worry that if you have something similar, multiply that and mushroom that by how many orders of magnitude, you got your hands full. You're going to have nothing but, no offense to the lawyers here. We love lawyers, but we also need a combination of people who can do that as well as implement.
I mean, I feel better. I
personally
feel better about U.S. regulatory agencies writing the cybersecurity rules for U.S. companies than I do about European
you and me both.
Regulatory agencies writing it for U.S. companies. That's my personal view,
Yep,
but
you and me both.
that is the direction we're headed right now with the Cyber Resilience Act. And then they also have a few directives that are out there that are going to cause a cascade of regulatory structures around them too. So I think that you are going to see the Europeans lead there the way that they've been leading in privacy. In the regulations, and the U.S. has been following.
And Ari, you've looked at this from the exec, but at CDT, this was an area that I'm sure was near and dear to you at that time. And there are analogies. There are also some differences, no?
There are big differences.
Done right.
I mean, because one thing about security is security policy is basically usually made when there's an incident that happens, there's some control set that builds around to solve that incident, to solve our vulnerability comes up, and there's some control sets that are built around to solve that kind of vulnerability. And then we build a structure around those and say, okay, you should be doing this stuff. And then it gets built into a code of practice. And then from there, sometimes it becomes regulatory, sometimes people just do it. So it's about the incidents and the vulnerabilities that are out there, and then we see them, that we build this control sets. Privacy is the other way around. Privacy is like, we're basically saying, here's a set of practices that we'd like to see and that people should do that are fair to the user and fair to the consumer in this space. And here are some controls that you can do to do those things that are fair to the consumers, to the consumer, and it's less reactive in that way. So it's the bottom-up nature of security means it's more accepting, and people are more willing to put money into it from the beginning.
And PII data and data that could be detrimental to our national security are not always the same. I mean, in all sincerity, assume your data to one extent or
there's
another.
A lot of crossover. There is a lot of crossover between security and privacy. I mean,
Yeah.
you can't do privacy without security,
And
for
vice
example.
versa.
And there's a lot of security that you can't do without privacy, but it's not some total overlap. Yeah,
issues as well.
I think that one of the takeaways here should be for the private sector broadly to consider how to change this situation and whether or not having something like a comprehensive or harmonized cybersecurity regulation might be in their best interests. Industry eventually came around to that for privacy and did breach notification. But as we discussed, it might be a little bit too late, or at least in the short term, to get there. I think I'd had an organization that I work with tell me that they were proud that they were one of the ones to call for comprehensive privacy legislation at the federal level as early as 2018. But this has been on the radar of government since when did you testify, Ari? Is it 1998? Was that
1998? Yeah.
Right. So it's we should not wait that long for cybersecurity.
Was that John Kyle? I testified. We might have been at the same
No,
hearing.
it was a House hearing.
Okay.
I'm trying to remember who that was.
No worries. I'm sorry for
probably
jumping
Tom Barton,
in, but yeah. Sorry, I cut you off.
Oh, no, it's okay.
So not that you led the witness, but I actually, what are your three takeaways, Ari? in terms of what it is and also what
personally, I think,
institutions
this
should be
is,
thinking.
who's this really great for? This is really good for trial lawyers who are going to be, or not trial lawyers, lawyers for trade associations, I should say, that are going to be pushing against this. So it's very good for lobbyists that need to be very much more, legislation needs to be much more precise. So they need to get in and do that. And the policy experts that feed into that discussion with the lobbyists to get the lobbyists open the door and the policy experts come in and do that and go into more detail. That's who it's probably best for immediately. I think the bigger takeaway though is that there's going to be uncertainty. We're going to have court splits, right? Where one court's going to say this reg should be interpreted this way.
Part of that could literally be defined based on the incident, right? Because you can interpret incident differently. So that, and you can have incidents that have, I think, outsized sort of impact.
That's a good point. I mean, the case, we always say bad cases make bad rulings for bad law.
Yeah.
So, and I think that's going to be the situation here too. If we can get cases where there can be more certainty around them, that would be great. But that's not going to be not very likely the case in a lot of these situations. So,
Harley, any other takeaways?
So I think Congress needs to be more clear about its language and about its intent, and more deliberate about cybersecurity legislation. Agencies need to, as best they can for rulemakings going forward, draw a line as clearly as they can to that legislative intent, which might mean more narrow, more focused rules. And I mean, I respect the work that agencies do. They're in a tough position. They're trying to match their regulations with evolving threats. We don't want to see all of that overturns. Stick with solid ground. For the judiciary, I hope that the judiciary takes seriously that cybersecurity and technology is a highly technical discipline, and makes an effort
There's opportunity there
to gain education. I think there is opportunity there, and I bet you that there's appetite for it too. But like anyone else, they're super
Overworked.
busy.
Yeah.
That's right. Yeah. For the private sector, again, I wouldn't make any big changes right now. But I think that keeping your eye on the ball and staying on risk management is very important. Even if it's not something that is strictly required by compliance, continue to manage your risks, go above and beyond, and consider whether or not to be more vocal about the need for Congress to act in a way that's harmonized and consistent to protect us all.
That very well said, both of you. The one. Friends of mine often say a pessimist is an optimist with experience. I tend to remain optimistic on a lot of these issues, but getting laws passed is hard. I'm very proud of the track record my colleagues had at the Solarium Commission, but I think that's a once in a not every year opportunity. I just worry that it's hard to get a post office name these days, let alone complex laws. And once we get a little more prescriptive, it's going to get even harder, I think.
I'm going to stick with Harley's last point on the optimism side.
I'm optimistic on this too.
If we can keep people focused on risk management, that's going to be the best outcome of this whole thing. Is like if you can just say, right, if you stay focused on risk management, doing real security, figure out where your real risks are, then the compliance can fall underneath that. Like you can
go figure. That's actually good for the country, for the client,
right.
for
that's
customers. I'm glad you both foot stomped that. Last question. Any questions I didn't ask that I should have?
You didn't ask about AI, and I appreciate that. Thank you.
That's a good answer. Great answer.
Yeah.
Gentlemen, thank you so much for joining us today. Thank you for all your hard work. Thank you for continuing to fight the good fight. This fight is by no means over, and however we interpret or others interpret Chevron deference and the overturning, we will still be at this problem and fighting it. Thank you.
Thank you.
Thank you for joining us for this episode of Cyber Focus. If you liked what you heard, please consider subscribing. Your ratings and reviews help us reach more listeners. Drop us a line if you have any ideas in terms of topics, themes, or individuals you'd like for us to host. Until next time, stay safe, stay informed, and stay curious.